Welcome to Risk Engineers Talk Governance. In this episode, due diligence engineers Richard Robinson and Gaye Francis discuss Safe Work Australia's best practice review of the Model Work Health and Safety Act and regulations and outline their submission response. We hope you enjoyed their chat. If you do, please give us a rating and subscribe on your favourite podcast platform. If you'd like more information on R2A's work or have any feedback or topic ideas, please head to the website r2a.com.au. And tickets are also still available for our live forum, in person and online, on 21st of October 2025. You can find the link in this episode's description.
Good morning, Richard. Welcome to our podcast session.
Good morning, Gaye. Welcome back.
Thank you. It's been 2 weeks of school holiday, so it's nice to be back.
I'll mention this to your kids the next time we see them.
True. Straight into it today. What we're going to talk about today is Safe Work Australia has a discussion paper out titled Best Practice Review of the Model Work Health and Safety Laws. Discussion paper dated September 2025, and they're asking for submissions till the 3rd of November. And of course, R2A can't help itself, but we need to respond to these sort of things.
Particularly since there are some glaring contradictions, insofar as we can tell from the point of view of designers. Section 22 of the WHS legislation, or Section 28 if you happen to be in Victoria, which requires the SOFA application, and there are some they're really categorical contradictions, which we've never quite understood. And it does be sort of one would hope that WorkSafe would be willing to have a crack at the legal framework to try and fix these things.
I was just going to say that the key questions for this sort of best practice achieves the object of the Model WH Act, Section 3. Within this context, how do we maintain best practice in response to the changing nature of work and emerging risks? And how can harmonisation of WHS laws be strengthened and maintained across jurisdictions into the future? And I think getting that consistency across a whole lot of things, and we've sort of got 3 key points, and we might go through them. We'll go through them today. It's really that the Act versus the regulation and the code of practice.
Correct.
And there's a contradiction there, and we'll go through that in a little bit more detail. I think there's a huge mess around the hierarchy controls of what's in the legislation compared to the common law, and then what the regulators are promoting.
Correct.
And I guess we've come from it from a practical viewpoint of a practical implementation of the WHS legislation, especially for designers and engineers. And that sort of leads on to what you were saying before about the designer section, Section 8 in the...
Well, the other one is the basic non-alignment of planning law with WHS legislation, which has got us confused as engineers. And as far as I can tell, the lawyers aren't clear on it either. You might recall we're going to talk about it, so let's not go there at this point.
So I think you've given the introduction of the contradictions for the designers and the requirements of designers.
Yep.
And so I guess the next one is the contradiction of the Act and the code of practice in particular.
This is one which keeps emerging. The code of practice follows pretty much the risk management standard. So I'm just going to look at the little diagram that the most recent one puts out. And it says identify hazards, assess risks, control risks, and review risk controls. And that pretty much follows the risk management standard, which, so far as we can tell, doesn't follow the process that you need to in order to survive common law scrutiny and presumably statutory.
I think, and when we say assess the risk, we're talking about consequence and likelihood, aren't we?
Correct, so, that by risk assessment. Yes. So you can have high consequence, low likelihood to be low risk still.
Yes.
Despite the fact that something really nasty, so it's high consequence, low likelihood could still occur. Now, the way we always do it, and we've tested it for so many lawyers, it really sort of got to the point that
We're not quite bored with it, but, it's going down that path.
But our recommendation is you follow what we understand to be the common law approach, and that is you identify the critical ones, the ones that can kill and maim.
Yeah.
Then you identify the further possible precautions that could be put in place, and then you work out what's reasonable in the circumstances based on what you know, which then is supposed to be an objective test, and then you have a QA system to make sure that what you've agreed is sustained. Now, that actually contradicts the risk management standard approach very thoroughly.
And some of the commentary that goes with that. It's sort of for known hazards. If there's known solutions, you just put those in place. But what we're saying is the so far principle actually asks you to look at all of the controls that could be put in place.
Correct, for the critical ones.
For the critical ones, and then determine what are reasonable in the circumstances. So that might be more or different to the ones that are already in place.
And it may well be different to what's in a standard.
Yes. So you just have to be careful there that, you know, you're not just doing what everyone else does or what's common practice, because it may not be relevant in the circumstances.
Correct. And it will be the judiciary that decides what's relevant in the circumstances.
Yeah.
I mean, it's you know, the way it actually works, I mean, something bad happens, somebody gets killed or maimed, it goes to court, all the experts pop up after the event and say with the advantage of hindsight what could have been done, which isn't that hard.
Yeah.
And then the court decides in all the circumstances whether the ideas dreamed up by the experts were sensible in view of what was known at the time the decision was made.
I.e., were they reasonable?
Yep.
So yes, that's probably the first one, and we're putting that in our letter. The next one for me, and this is the one that probably annoys me the most, is the hierarchy controls and the different commentary that's going around about those, and especially from regulators. So we've covered this many times. The WHS legislation has a hierarchy of 2. You must eliminate first, and if you can't eliminate, you can reduce it so far as reasonably practical. When you go to court, it's divided into three categories: elimination, prevention, you stop the thing from happening, and then mitigations, which stops the escalation of the consequences or reduces the consequences.
And the example we usually give is of the railroad crossings, level crossings. Obviously, if you want to eliminate, you can grade separate, great expense. Or you can put up boom barriers, which will stop the incident from happening at all. And if that fails, you go with crash worthiness. All of which happen to be engineering controls, and which engineering only pops up typically as 1 out of 6 controls that most regulators put up.
And that's probably the other area, is that how regulators do it, and we've seen them everything from 3 to 4 to 7.
Well,
sort of
different jurisdictions have different
Yes.
things, but the most popular one seems to still be 6.
Yeah.
With eliminate being the top and then another 5. But Victoria's down to 4, I think. And sometimes you see in Queensland, they've got both 6 and 3. It's very confusing if you're a designer as to which one you're supposed to use.
And they've also grouped some of them together, so isolation engineering and substitution.
Well, that's how they shrink it down. What's interesting from our point of view is they're getting closer and closer to what we understand to be the way the courts go about it. But they, for some reason,
the terminology is not the same though, and I think that's where it's confusing. So I think to harmonise the WHS legislation, if the regulators could get on board of what and agree to it.
It would be really helpful if the regulators would talk to WorkSafe Australia, I think.
Yes, and streamline that process. I think that would take a lot of confusion out for engineers. And the third one is probably Richard's favourite part at the moment, is the planning legislation.
Call it favourite.
or the area that's causing the most difficulty and confusion is the planning laws and WHS legislation.
Yeah, because what seems to be happening is that planning law basically has a life of its own, unless there's some forced connection between WHS legislation that seems to be ignored. I mean, probably the one that hit us the hardest, and that I've got to say practically, was when we did the hazard and risk analysis for the EIS for Western Sydney Airport, because we didn't start the job till we got the Australian government solicitor to agree that the owner and operator of the airport had to comply with the WHS legislation. But then when the planning process went through, we sort of got told, well, you don't have to follow the WHS legislation for the EIS. And that's really weird, because most of the core hazards are set up right at the start of the planning process.
Well, set up, but also able to be dealt with at the easiest part on a pen and paper and a planning stage than it is once it's been implemented.
Yeah, no, I think we've already spoken about it, so I don't propose to go into it here. But the only time when we've found a good connection between the two is when the planning law has a requirement that advice needs to be received from the relevant regulator, for example, major hazards, in which case the planning system actually does take cognizance of the obligations, but then it's more the obligations.
Only if it's brought up, though.
That's correct. It has to be forced into the system somehow.
Correct.
And in that sense, in Victoria, the VCAP one we're talking about, the council had to actually ask the opinion of the WorkSafe Victoria with regards to a major hazard facility. WorkSafe Victoria presented an opinion, therefore that opinion then had to be thought about.
Yeah. So And I'm sure there's other legislation that would have conflicting requirements as well, but that's the one that we've sort of come across.
Yeah, they're the three, the sort of the three biggest that we've come across, which obviously we're going to advise.
Yeah.
And for those of you who are contemplating coming to our October event with regards to the SOFA business, these sort of questions will pop up there, possibly depending on what people ask.
Yeah, and the discussion will sort of be around these things. So I think, as we said before in our podcast, we're not actually sure what the event will turn out like and what discussions will be had, but
we're pretty sure it's the questions that are going to be the best part.
The discussion part will be the best part. And I think some of these things that we've been talking about, there's no one answer to do it, but there's ways and people think about these things differently. And I think that's the important part, that these difficult conversations are being had.
Well, it is also interesting if you look at the larger thing. I mean, the WHS legislation was an attempt to get societal alignment from problems that arose since Federation. Big step forward. But it went to the highest level, the parliamentary level, and even Victoria still has to adopted it, even though we have the SOFA business, we don't have the due diligence business. But we've certainly got all the obligations of designers that are pretty much the same. But then the next level down, in effect, is what we're actually talking about. And that harmonisation hasn't happened properly yet, which is what WorkSafe are actually asking for.
And I think if anyone was interested in going through that discussion paper, it's actually a good read, and they've sort of put the differences between the different jurisdictions. So even though you've got a model WHS Act,
you haven't got the regulators have model allies themselves yet.
So there's some harmonisations, and there's been a number of tweaks to the legislation that makes each jurisdiction that little bit different from each other. So they're sort of saying, is there some consistency that can be thought through?
Well, we don't know what motivated this particular best practice request. We have some suspicions that the points we're making may be relevant.
Yes. So I hope you found today's podcast interesting. Thanks for joining us as always, Richard, and we'll see you next time.
Thanks, Gaye.